So today in the recap of prelims, so we are going to see some articles which are in news in the year 2024, month of Jan and Feb, right? So in this, today we'll try to start with these articles which were in news. So Article 142, so which was in news. So anybody know why it was in news? Article 142. Okay.
Mayor posts.
Huh?
In Chandigarh, mayor posts regarding that issue.
Yeah. So in Chandigarh, we had the mayor post, which was a mayoral election in which the Supreme Court overturned that electoral process. So there were many other instances where we had this particular article 142, which was utilized in a variety of sense, right? So there were even some compensations which were given in recent past. So we can say different aspects we used 142 or Supreme Court invoked Article 142, right? So here in this context, so what is Article 142 all about? What does Article 142 says?
But in summary, like it can talks about the complete justice, like even Supreme Court can go beyond the limit of it and like it can do justice.
So go beyond in the sense, what does it mean?
The descriptive powers of the Supreme Court.
Within the constitutional mandates, right? So within the constitutional mandate, you can provide complete justice, or you can involve in providing decrees or orders to do complete justice of this in this particular case. So that's the idea what actually 142 mean. So in the words of the Constitution, it says that it empowers the Supreme Court to pass any decree or order necessary for doing complete justice. Okay, they try to make the word complete justice. Clear? So this is the thing which they try to highlight. Fine. This complete justice, what they try to have, say for example, it doesn't mean that it has a complete overarching power where you can do anything as you like in the name of complete justice, because we have different Supreme Court judgments since 1990s, where the first such case in complete justice, it came up with, you remember the Union Carbide case, that is in Madhya Pradesh, Bhopal gas tragedy. So in that, for the first time, they highlighted this particular aspect. Okay. And then there were some other judgments related to Supreme Court Bar Association, and similarly Jubilee Hills case. So even recent Umadevi case in Karnataka. So in all these, they have reiterated that these the idea of complete justice comes based on law and not based on sympathy. Got it? So it is not based on sympathy, but it is based on law. Understood? So according to law, what it can be done? Okay. In that law, you can just go certain extent in with the spirit of law than the letter of law. So you may interpret spirit of the law, and you can bypass certain statutory provisions, and thereby you enhance the judicial progress, where you try to have that particular idea of complete justice. Got it? So this is what we try to have the idea of complete justice. So this complete justice emanates from Article 142, but it is supported by certain articles like 141, which talks about the record and abiding the rules of, the judgments of Supreme Court. And similarly, Article 32, guarding fundamental rights. Article 13, which gives a power where the fundamental rights are protect it against laws. And similarly, Article 129, which gives contempt. So all these are supportive articles which provide this particular complete justice or enables this complete justice. But when you understand this particular concept of complete justice, there comes another idea of judicial activism. So what is judicial activism? What is judicial activism?
The courts taking much suo motu cases, much eagerly.
Okay.
Sir, in a democracy, an undemocratic process, like to where like you enter into the areas of the executive and the legislative. So.
Okay. So actually, judicial activism is a active role of judiciary, right? So it is an active role of judiciary in which you try to go beyond the separation of powers, or you try to interfere in the jurisdictions of executive and legislature, right? So this is the idea. But judicial review is actually where you try to Article 13, which calls for judicial review, it tries to declare law and how this particular law is constitutionally compliable, compatibility. So that you need to check. When you say that it is not going to be compatible, and you need to, and when the judiciary says or dictates that you need to do in this particular method, in this particular system, this is how you need to do, then activism comes in. Okay. But what judiciary says, to give complete justice, I say that this method or this particular law has to be implemented in this particular manner, in this particular case, then I say it is complete justice. But in general, if the Supreme Court or any other court, that is higher courts, they try to dictate terms where in the name of judicial review, you try to dictate that this is how this particular law has to be interpreted and this is how it should be implemented by breaching certain jurisdiction, then we call it as activism. Sometimes this activism turns out to be judicial overreach. So judicial overreach means it is something undemocratic way of exceeding all limits and authorities and trying to confer this particular powers upon themselves. Say, for example, sometimes Supreme Court says there will be a legislative process, and the legislative process, say, for example, in one state legislative assembly, the voting has been done. So Supreme Court directed that the voting will be done and voting results should not be declared, but that particular results should be submitted to the Supreme Court, and Supreme Court will review and then it will be declared. So that is absolutely judicial overreach. Why? Because Supreme Court doesn't have anything to do with the procedure of the legislature, because the procedure of the legislature is completely undertaken by its own rules of procedure. You have the constitution which devises its role, and speaker is the supreme authority there. Got it? So in that particular set, telling that how the voting should be done and how sending observers in that regard, and then coming back with the results, and after Supreme Court validates, you need to declare. So that is judicial overreach. Got it? So all these are resting in this idea of complete justice. So judicial review, judicial overreach, and activism and judicial overreach. So why judicial review comes in? Because Constitution says that under Article 13, so you need to protect the fundamental rights, right? So you need to protect fundamental rights where the laws should not be inconsistent against fundamental right. Clear? So that's a basic idea, and it clearly, Article 13 clearly segregates two sets of rights or two sets of laws. One law which is before Constitution commencing itself, whereas after the commencement of Constitution. So before the commencement of the Constitution, anything is going against the fundamental right, it will be literally dead. Okay, so it will be eclipsed. We use the doctrine of eclipse. Whereas any article which is legislated after commencement of the Constitution, it cannot be inconsistent with the fundamental right. In case if it is so, then actually you have the doctrine of severability. Severability means you just cut that particular part and nullify that particular part, whereas the rest of the part of the law will be legal. In case if the meaning of the legislation or the law, in case if it doesn't work, or in case if the such a severing of a part of the law almost nullifies the entire law, then automatically the entire law will be nullified. That is, say for example, there are 3 points which are given by the law. First point is against your constitution. So doctrine of severability says first point will be illegal, whereas 2 and 3 will be legal. Say when I make 1 as nullified, that implies that 2 and 3 doesn't exist, because 2 and 3 exist only when 1 is there. Then automatically when 1 goes, 2 and 3 also will go. So that is what the doctrine of severability is undertaken. So Article 13 is clear about what is judicial review and how the judicial review should be happening, right? But in this process, they try to have these type of activism, right? And that is how you had 24th Amendment, which inserted certain clauses in Article 13, where constitution amendments made under Article 368 will not apply to this particular thing. Okay. Now the question is, fundamental rights can be amended, correct?
Yes, sir.
Now, a constitutional amendment is made upon a particular fundamental right. Okay. Whether this particular amendment comes under Article 13.
Yes, sir.
Whether the Constitution comes under Article 13. Remember, it is not.
Yes.
Okay. So it is not, because Article 13, Clause 4 is upheld by the Supreme Court, because Supreme Court upheld the 24th Amendment Act, right? So that means what? This 13 Clause 4 is upheld. But what they did in what do you call the Keshwananda Bharati case, they said the doctrine of basic structure. Whatever may be the constitutional amendment, in case if it is affecting the basic structure of the Constitution, which includes fundamental right, then in that particular graph, it is going to be reviewed. Understood?
Yes, sir. Got it, sir.
Okay. So that is the importance of Article 13. Okay. So say Article, 9th schedule, as you asked, 9th schedule after Keshwananda Bharati case, it is reviewable. Right? Because the latest judgment says that after Keshwananda Bharati case, 1973, anything which is included after that can be judicially reviewed. Clear? Because the recent judgment says that. Fine. So this is the actual state. So complete justice, in the name of complete justice, all these articles try to provide Supreme Court a special position with respect to guarding the fundamental rights or guaranteeing this particular aspect. Got it? Fine. In this particular regard, in case if I have some issues, say for example, when a judgment is delivered, say for example in 142, I have some judgment delivered. But I feel that the government feels that some miscarriage of justice is happening. Some facts have not been considered. So there are some issues. Then automatically we can have some curative petition, right? So we have curative petition, review petition. And this curative petition or review petition can be possible under Article 137, which provides for this particular review, right? So that is a most important aspect what we have. So that we will see. So you can see
Sir, one question, sir, like, sir, so can we say that complete justice is like the judicial review plus judicial activism plus judicial.
No. Complete justice is a one where it is a duty of the Supreme Court to provide relief or compensation for the victim where the law is not sufficient to do so. Right? In the garb of it, sometimes it results in activism. Got it?
Okay, sir.
So judicial review is another way in which activism comes in. Fine.
Okay, sir.
So at times judicial activism is acceptable because there are certain lacunae in the law or on part of legislature or executive. But it is not a regular phenomena. It is not a regular feature which can be accepted. Clear?
Yes,
On
sir.
the other hand, judicial overreach is unacceptable. Got it? Judicial overreach is unacceptable because it will undermine what you call democracy. Clear?
Okay, sir.
Fine. So this is a basic idea what we have in this regard of complete justice. So in case if some issues are there in the judgment, so then we can go for curative or review petition. So what is a curative petition? Curative petition is something which says that after the judgment is delivered, okay? So what Supreme Court does is that a plea for preventing a miscarriage of justice or some legal process have been abused by the petitioners is being found. Then what we have the idea of curative petition, right? So it is supported by Article 137, where the Supreme Court can be approached, and it can be approached and only in a narrow ground that there are some procedural error or some miscarriage of justice where misinterpretation has been done. So ultimately, we have the request with the approach of Supreme Court, and Supreme Court has its own discretion in doing so, whether to accept it or not. Okay, so this is curative petition. So something cure. What is cure? You have, it's a remedy. So something has happened, so you are trying to cure it. Okay, that is curative. Review means it is a prayer before a court of law where some mistake has been provided. Say, for example, in this one, that is your former disappropriation appropriation case in Jayalalitha period. So the judgment was based on certain sum of income, and they arrived at one number, and they said this number is not that much greatly varying, so we can consider that it is not much of misappropriation, right? So in that there was an total error, okay, a number error. So it is a grave error because the entire judgment was placed upon the number, but the number is not a right number. So possibly there should have been a review petition, but unfortunately there was no review petition which was gone from the government side, right? Because the government has to do it, but the government didn't do it because it was the same government which was in place. So that is actually a grave error or glaring omission or a mistake. So in that case, they have to go for review petition, right? So here they went on for a special leave petition where they directly went to the Supreme Court asking for a direction that this particular court has made some grave error and you need to provide certain things. So that is special leave petition where under Article 136, directly you appeal to the Supreme Court from any order of the lower court. It may be high court or tribunal or anything, any kind of court, a special court or fast track court. Directly you go to the Supreme Court through special leave. What is special leave there? Leaving all other appellate, you directly enter into the Supreme Court. So there are three petitions: curative, review, and special leave. Curative, you try to ask for review of justice, where the judgment can even completely change, right? Whereas review petition, the judgment overall aspect will be there, but certain errors maybe or certain observations may be omitted, right? Whereas special leave petition, it is a petition where you get a appeal directly to the Supreme Court, cutting across all the procedures, and I mean directly from any other court, or for example, a tribunal or a fast track court or whatever it may be, for providing a overall judgment. So in all these cases, Supreme Court has a right to accept it or reject it, and if it is done, it is final. Got it? So all these are articles which are there in current affairs with various reasons, but you can link it in this particular manner. So even in prelims, in case if or mains, in case if there are questions, try to have some idea how these statements are interlinked. So 142, what is its link with 32, 141, 13, and 129? Clear? And how it is linked to it, so that in case in mains, if they are going to ask you what is complete justice and how it is being ensured by Supreme Court and what are the supportive arguments for it, you can go in this particular fashion. Clear?
Okay. So, sir, like review petition, sir, can you just once explain, sir, like?
The review is for some factual errors. You are not changing the entire judgment there. It is
Okay,
just
sir.
a correction in the judgment. Okay.
Whereas,
Whereas,
sir, it is a, okay, sir.
Whereas curative, you almost revise the entire judgment kind of.
Sir, review, sir, like which article is like under which article, sir, we can have the
Actually,
review
review and curative, it is almost 137 only, because it is it's not a constitutional provision which provides so. It is just an enabling provision, that's all.
Okay, sir.
What 137 says, it can review its own decision, that's all, right?
Okay, so.
So based on that, Supreme Court has its own method to review it. So they gave two different aspects. One you call it as curative, another one is review. And that's the reason you can see the Supreme Court laid a guideline under Rupa Ashok case, where they try to have some curative petitions, how the petitions have to be taken and what are the criteria it should be. So they provided a guideline. That means what? It is not providing the constitution or rules of law. So it is an innovation of the Supreme Court under Article 137. Clear? Same is the review. Fine.
Sir, like the Supreme Court has stated the implementation of the farm law. Like, was it a judicial overreach?
No. What Supreme Court said there?
I'm like means I'm having the confusion, sir. Like, was it the judicial overreach?
Yeah,
Like,
actually, what Supreme Court did in that particular law?
no, like they said that they have right to state the implementation, so they can do that.
Oh, yeah. So, see, any law can be stayed by the Supreme Court. That's no doubt about it.
But without.
Why you say it is overreach?
Sir, because, sir, like until I will not consider about the constitutionality of the law, means can the Supreme Court like state the implementation of the law? Means like
See,
I have not
what is
violated whether the law.
See, what is a problem in that particular law? It is not the constitutionality of the law which was questioned.
Yes, sir.
Clear?
Yes, sir.
If the constitutionality of the law is questioned, it would have been upheld because there is no procedural error in which it happened, or it was not a violation of a constitution. Clear?
Yes, sir.
The grounds on which the farm law was challenged was, it said that the law infringes our basic livelihood, and these are certain points in which the contention is there, which was not considered. So that is what the group of farmers they went on. So
Okay.
the implementation was given a stay because the implementation is the problem there. The farmers' contention is that when you implement, my livelihood is affected. So the law were suspended from implementation, and Supreme Court suggested a negotiation between the government and the farmers. And they had a committee, and the committee was monitored, and it submitted a report, correct?
Yes, sir.
So after that, Supreme Court didn't declare the law unconstitutional. What happened to the farm law? It was repealed by the
Legislature
government,
itself.
correct?
Yes, sir.
So in no way there is judicial overreach, right?
Sir, can you give an example like where there was a judicial overreach so that I can relate it better, sir?
Judicial overreach, you have the one which I quoted in the state legislative assembly where the Supreme Court governed the entire functions, okay, of the voting system. And another case is that when CBI was asked to conduct the entire inquiry, and the inquiry report was to be submitted to the Supreme Court itself. So Supreme Court cannot head a investigation wing, right? But in a particular case, Supreme Court ordered CBI to submit report to itself. That is a judicial overreach. Clear. What you can do, you can order for a CBI to inquire. That's all. But you cannot order CBI to provide a what do you call report to itself.
Yes, sir.
That and all overreach. Fine.
Yes, sir.
Okay. Fine. So tomorrow we will continue with other topics in polity. Thank you.
Thank you, sir.